Hi, everybody. My name is Catherine Sullivan DiCarlo. I am the Vice President of Admissions and Marketing at Chapel Haven Schleifer Center. And we want to welcome you to the final in our three-part series about benefits and planning. Some of you, I think, have been here for all three sessions, and some of you may be just popping in for this one. We really want to thank the Drazen Rubin Law Firm for volunteering their time to do these workshops. We've had a tremendous response, and so we're going to get right into it. But first, I did want to mention that Chapel Haven has been doing a lot of different things. We have a virtual open house coming up next Wednesday at noon Eastern Standard Time, and we're also planning a workshop on getting ready life after high school, and you'll get more information about that. That will be next Thursday. So if you're interested in Chapel Haven and our pathways to adult independence, please join us for some other events that we're doing. I'd like to introduce Stephen Rubin, and I'd like to thank the Drazen Rubin Law Firm. They're based in Milford, Connecticut. And both Stephen and his partner, Franklin Drazen, are certified elder law attorneys. And as we've learned over the past 2 weeks, they're extremely knowledgeable about special needs planning. So today, Stephen is going to conclude our series with sort of bringing everything full circle that we've been hearing about for the last 2 weeks, and especially talking about estate planning. I understand that he's going to also touch on the ABLE account, which is something we get a lot of questions about. And what we're going to do is Stephen will present, and if you have a question, you can type it into the chat function, and we will get to your questions probably midway through the hour. So without further ado, introducing attorney Stephen Rubin.
Oh, good afternoon, everyone. So I'm going to start off without switching the PowerPoint around and just talk about ABLE accounts a little bit. So ABLE accounts, which stands for Achieving a Better Life Experience, is actually what the legal name for the accounts are. They're also called 529As. And basically, the idea behind the accounts is it was supposed to be a financing tool that was going to provide for some tax advantage savings. One of the advantages with an ABLE account is that we can transfer money from other types of 529 accounts into the ABLE account. In fact, there's a really cool way of getting a tax break in Connecticut and doing it for the parents. So the idea behind them is, holding income, which may be necessary for some people. It does not, a common myth with ABLE accounts is that by putting money into an ABLE account, you are reducing someone's income. That is not true. An ABLE account is not for reducing income. It helps reduce assets. So for example, if I have someone who is making too much money to qualify for a benefits program, diverting that money into an ABLE will not allow them to qualify. However, if I had that same individual making too much money for certain programs, diverting that money into a first-party special needs trust will make them eligible to qualify. So ABLE accounts and first-party trusts work in a very similar fashion, but they have different legal rules behind them. One of the big things that the ABLE account was supposed to be helpful for is funds for education, funds for housing, can be used for assistive medical technologies and expenses. And in order to qualify for an ABLE account, anyone can become eligible for the account as long as they were diagnosed with the onset of a disability prior to the age of 26. Now, that's an interesting thing, because what does it mean with onset prior to 26? A lot of it historically has meant that as long as the person was diagnosed prior to the age of 26, that they would qualify for the disability benefit. It does not require necessarily that someone be disabled at an earlier age or that we show disability. And a lot of the disability rules have been kind of just made up along the way. For example, I have a client who works full-time. But he was diagnosed with autism prior to turning 26. Therefore, he has an ABLE account. Now, he doesn't need it for medical purposes. He's using it because he can, was his explanation. He wanted to do it for tax savings. not because he really needed it. So he put money into the ABLE account. It's not going to reduce his benefits or anything else. It has no impact on benefits for him. For others, it's designed to give them some independence. The ABLE can be established by any parent for a child. It can be established by someone who's a legal guardian for someone. It can be established for someone who has a power of attorney over somebody else. So one of the things that ABLEs do is that when money is moved into an ABLE account, the contributions are basically made post-tax, meaning the contributions are not considered taxable. Now, they're also not considered tax deductible for the individual who's making that donation. So for example, if I were to put money into an ABLE account for someone, I don't get a tax break for doing so. However, if you are a Connecticut resident, there is a trick you can utilize to get an income tax deduction. And the trick is to create a CHED account, because if a parent puts money into a CHED account for a child, they get an income tax deduction. The CHED account can then be rolled over into an ABLE account. So there are ways to set up ABLE accounts and set them going forward. ABLE accounts can be also useful if they're set up under two different rules, like the Uniform Gift Act to minors or the Uniform Transfers Act. So there are ways to do gifts and without tax advantages, but it puts money into a child's name. And one of the things we want to avoid is that old method of doing things, and that's kind of where the ABLE account fits in. So back 5 years ago, it was very common for a grandparent to put money aside for a grandchild with like a savings bond and put money directly into their name. Well, we want to avoid that because we don't get any protection on those funds. The ABLE account, having a grandparent put money into an ABLE, gives us a little bit more protection. There's some benefits on taxes with distributions from ABLE accounts that you don't get with other kinds of accounts as well. So there's part of where we want to use them. A big thing to know, though, with ABLE accounts is that there can be a suspension of benefits if the amount of assets increases. So currently, if you have more than $100,000 in an ABLE account, you're ineligible for SSI benefits. Another catch with an ABLE account is it has a Medicaid payback provision. So if someone has an ABLE account when they pass away, those funds have to be used to pay back the state. Now, there's been a lot of media ploy about Maryland coming out and saying, hey, we are not going to require payback from ABLE accounts. There was a little hidden memo there, though. It said we wouldn't require payback unless we were required to do so under federal law. They're required to do so under federal law. So while they did that to try and get out-of-staters to create ABLE accounts in Maryland, they still have to collect the money because federal law says they have to collect the money. It was kind of a little thing that they pushed for a long time, but it's not something we really care about that much. We do not have a true ABLE Act in Connecticut. It has not been authorized or set up. That does not mean someone in Connecticut cannot have an ABLE account. In fact, you can. We just use ABLE accounts from other states. My personal favorites so far have been the stable accounts from Ohio. We've also used the ABLE accounts in Massachusetts. It is situational which state we want to be looking at. And part of what we look at when we're looking at the different accounts is we want to look at how much activity that account is going to have. So for example, if someone is going to just put money in once a year and they're not really going to take anything out, then an account that pays better and does a little bit better in the management side and has more flexibility on the management of the money might be better than an account that is going to charge by the transaction. So we have to look at the way these work. There are fees associated with the accounts. The banks do charge a fee for them. It depends on the account and how much money is in there, obviously, but there are fees associated. So we always want to look at how it's going to work. It is an account that can be used to pay for education. You could pay for Chapel Haven using funds in an ABLE account. That's one way of handling it. And it's a way to roll money that might have already been set aside for someone for college or other educational funds into the ABLE account. So the money that's in a standard 529 isn't lost. Now, ABLEs do have caps on them for how much money we can put in, though. So the maximum amount that you can put into an ABLE account per year is about $15,000. So we want to be making sure when we're adding funds into these accounts, we're not hitting the max. There's a secondary maximum, though, and that's for beneficiaries who are working. So if someone has an ABLE account and is working, then they can put the money put in about $26,000 this year. Now, this does not impact things like the stimulus checks. That was a myth I saw online on one of the boards in the last couple of days, was that if I have an ABLE account, it eliminates me from getting a stimulus account. No, it doesn't. The stimulus and the ABLE accounts are not connected together. They can be used together, but one has nothing to do with the other. The stimulus check is based on whether a person qualifies for the stimulus, and that issue is basically, are they a dependent or not? If someone is considered a dependent for tax purposes, they will not qualify for the stimulus check unless they're under the age of 17. If they're over the age of 17 and they're dependent, they will not qualify, period. And one of the questions is how hefty are those bank fees? It varies place to place, honestly. My general rule, the ones I've seen the most common, I'd say is a little under 1% a year. But it could be higher depending on the number of transactions that are involved. Generally, a lot of my clients who use them are not using them for significant amounts of transactions. We're only doing a few a year, so we're not seeing hefty charges. We're using these a little bit differently. There's kind of a hierarchy of needs when we look at ABLE accounts versus some of the things you heard about last week with first and third party trust. So when we're leaving money to someone who's disabled, the hierarchy is always, we want it in a third-party trust. Third-party trust gives us the most amount of flexibility over anything else. It helps us it's easier for tax issues. It's a lot easier for handling distributions. It has the least amount of triggers against it that could impact public benefits, less rights for the states to go after money. But not everyone can do that, because that's the difference of like third-party money versus first-party money, which I believe Franklin talked a lot about last week. But for those who didn't hear it, third-party money is someone else's money, essentially. So if I leave money to someone, that's third-party money because it's mine. Now, if I leave money to someone and they get it directly, that puts it as first-party money because it's now their money. If I leave it to them in a trust, it remains third-party money. So we always want to have things as third-party money because we want to avoid the claims that the state, Medicaid, the federal government can make against first-party money. So we want to always be careful. So when we look at funding an ABLE account and they say, $100,000 is the max, I have never had an ABLE account where we've come close to $100,000. I don't understand why anyone would want to put $100,000 into an ABLE, because there's better ways of handling that amount of funds than an ABLE account. So they're a tool. They're useful. They're definitely useful for transferring funds for educational purposes. They're useful for rolling a 529A. They're useful for smaller dollar amounts, and they can be really useful for independence. And that's part of where I like them the most. If we're having just small dollar figures in there, ABLE accounts are a great way to allow someone to be more independent, to pay their own bills. There's specialty credit cards that can be set up through ABLE accounts now that prevent people from buying things that are in-kind support and maintenance. So one of my favorite things about that is it allows someone to go out and buy food at limits, but you don't have to. It allows them to buy clothing, but because it's not in-kind support and maintenance. So we use it for specialty services so we don't lose benefits. To answer the question, can you roll a 529 account into an ABLE? Yes, you can roll a 529 account. Should you? I mean, that's a different conversation that we'll have to have later. But when we're looking at this, whether it's ABLE accounts, first-party trust, third-party trust, anything we're looking at is really about planning. And that's a lot of what I want to focus on today, is the idea of having a plan. Because most of us don't have plans. We don't think about a plan. This is one of my favorite quotes. It's about bringing something to the present so we can do something about it now. And I think that's really true. And if we think about it, we plan for almost everything in our life, right? I mean, maybe not right now with COVID, but in general, we're always planning. We plan for vacations. We plan for dinner with friends. We plan for birthday parties. We plan for a lot of things, but we don't plan for ourselves. And a plan for ourselves is going to be really important in figuring out how we're going to plan for children, because we really need to have all of these things work together. Plan should not be, a piecemeal thing. I had a call this morning from someone, and she said, well, what if we just did this now and then this? And what if we added this later? Well, okay, those are all really good questions. But the problem is we might have to redo some of those things as we add more into it, because a lot of things have to be designed to work together. We try to do things where, if the power of attorney is done, is it going to work with the trust? Is it going to work with the rest of the plan? What powers do we need to have? Those are some of the things we really want to make sure of when we do a plan, is we want it all to work together. So what really is an estate plan when we talk about these things? Because, we've been talking a lot about planning, but what really are we talking about? We want a defined plan. It's a defined plan for the management of our assets, either during our lifetimes or when we pass away. And that's a really big part of it. Is planning can be pre-death, it can be after death. Planning kind of takes on a different role. And we have to look at what our goals are. That's one of the first things you have to consider whenever you're going to do any form of estate planning. Isn't, hey, I need X, Y, or Z. Maybe you need it, but before we get into needs, let's figure out, what do we want to accomplish by having something? Let's kind of start with the basics. What's my goal here? Am I trying to provide for somebody else in the family when I pass away or during my lifetime? Is it someone who can manage finances, or do I need to have someone else manage the money for them? Am I concerned about taxes? Now, for most people, there's a lot of tax myths that are out there. For most of us, we are not going to pay estate taxes when we die. For a single individual, you have to have a little over $11 million. For married individuals, you have to have $22 million to pay estate taxes. So statistically, they figure there's less than 1,500 people in the country who have to worry about that a year. So most of us aren't going to hit those tax levels. But we might want to avoid other things like probate or family hostilities. That's a very common issue now, is my family fights. And I get that all the time. My kids fight, my family fights. Well, every family fights. So we might want to think of things to avoid that, or how we can prevent it from happening. So we want to look at, kind of the essential documents. And there's certain things that almost everyone needs to have. And there's common myths about how a lot of these things work. My personal position has always been the most important document in an estate plan. It's not your will. I hear all the time, it's my will, it's my will. It's not, because your will is only effective after you're deceased. What about while you're alive? Shouldn't we start there? And that's my philosophy, is there's, hopefully a significant amount of time between now and when we're gone. But during that period of time, if I look at the statistics, I'm going to need some assistance. So I want to make sure I have a good power of attorney. A trust or a will, those are really important documents to have. But again, power of attorney first. Who can talk to my doctors? Who can they get medical information for me? Who can make medical decisions for me? And to that extent, I created this nice little chart. And it says, these are the documents and when they help us. Because it's really a common myth of, hey, I only need one thing. Well, not necessarily. Because right now, having a power of attorney is a useful thing for me. Why is it useful? I'm younger. Why would I have a power of attorney? Well, what happens if I got sick tomorrow and couldn't pay my bills? I want to make sure that there's someone who can write my checks for me. I want to make sure that if I end up in the hospital, there's someone who can handle all of the financial responsibilities that I have. And if I got sick tomorrow, I want to make sure someone can take my dog to the vet. And believe it or not, that's required in a power of attorney. So I have all of those things as part of it. You know, I also have a pre-designation of conservator. Now, I hope to never need that, and most people don't. It's one of those documents that if you do it, I don't think you'll actually need to have it. But if you don't do it, you'll probably need it. I have healthcare directives. Again, why would I do healthcare directives at my age? Well, because my rule of thumb is if you're over the age of 18, you should do healthcare directives. It doesn't matter after anything else. If you're over 18, you need to make sure someone can make medical decisions for you if you cannot do so yourself. And that comes up. We actually had that issue last year where there was flu outbreaks at college campuses and parents were calling the school and couldn't get information about their kids. Having a healthcare directive, which has a medical release in it and would let the parents talk, would have been really useful. We actually created our parent sanity package over that last year because college kids still need some planning. They may not need a will, but they definitely need someone who can make medical or financial decisions if something happens. And then, when we're dealing with final distribution issues, that's where we look at wills and trusts. So we want to, we have to look at these things on a timeline of when do we need things. Now, a living trust actually works in all of these situations, and we're going to talk a little bit more about that. But because I love it so much, we're starting with the power of attorney. So a power of attorney is an individual that you name to make financial decisions for you. In Connecticut, we say that you're the principal and the person you're naming is the agent. And they have a right to act for you based under the terms of the document. So with a conservatorship, when someone is appointed by a court of law, the powers that they have are whatever the judge grants to them, which is usually going to be in a limited scope. That's why you'll commonly see people going back and forth to courts for conservatorship. With a power of attorney, the scope is what you decide it is. So you want to have particular powers in there. And that's where like the broad and limited authorities come into play. So for example, in my power of attorney, I have certain ones that are broader than others. My personal power of attorney has powers and they're related to my dog because I think I want to make sure she's safe and she's the most important thing I have. And I want to make sure that if I got sick, someone could take her to the vet. So I have a pet power in there. I have a power in there that also directs and allows someone to do activities that may not normally be allowed. So for example, a standard power of attorney limits someone from making a withdrawal from a retirement account to the annual exclusion amount. Well, if I'm only limited to my RMD amount or my maximum number, I don't have RMDs, I'm too young. What if we needed an emergency withdrawal? You have to direct that in the document. You have to grant that power specifically. A general power does not allow for that. A conservator is not allowed to do that either unless they got a court order. So we want to avoid the conservatorship, but we also want to make sure that when you do a power of attorney, it has to actually have powers in it. One of the most common examples I can give is when there's a husband and wife doing estate planning. Generally speaking, husband and wives own houses together as joint tenancies with right of survivorship. So if one of them gets sick, and for the gentleman on the call, it's always going to be us because I always pick on us. But if the husband goes into a facility first and he needs care and we need to transfer the house out of his name, can that be done with a power of attorney? Now, in normal circumstances, I'd make you raise your hand. But can it be done? Maybe. Everyone always says yes, no, or yes. The answer is actually maybe, because we need to look at what powers we have in that document. So what kind of powers do we need to have? Well, the first power we need is real estate, because, hey, it's a real estate transaction. But what other powers might we need? Well, if we're transferring the house from a husband to a wife, is that considered a gift? I see a few people shaking their heads. Is that a gift? Yes. A transaction between spouses is still deemed to be a gift. It does not matter whether you're married. Any transfer of an asset for less than fair market value is deemed to be a gift. Lawyers are boring. We define the dumbest things. So that's a gift. Now, it's not a taxable gift, because obviously transfers between spouses generally aren't taxed, but it's still a gift. So now I need to have a gifting power in there. Well, then I also have to look at something else though. I would presume that that house is worth more than the annual exclusion amount, which is $15,000. Well, now I need to have a gift that says I can do something beyond the annual exclusion amount. So it has to have a power for that. Then I would have to presume, let's say it's the wife who's acting as the agent. Well, now it's an interested transaction, and as a fiduciary, she's not allowed to do that unless we have a waiver in the document. So we have to add in that waiver. So these are all things that are not in a power of attorney, but that we customize to make work with our power of attorneys. And it has to be done to fit the situation. It's a very common myth that it is a one-size-fits-all document. It's a situational document based on what someone needs. So I have done powers of attorney for a couple pages to 40 pages, depending on the situation. And each state does have their own version. Although for the most part, we are accepting of other states' documents, there are some very important differences. So one kind of power of attorney that you'll hear more about these days is what's called a springing power of attorney. A springing power of attorney is one where someone is named on the document to act, and they have no power to act the day you sign it. The theory goes is that they have the right to spring into action on the happening of some event, usually a loss of competency or capacity. It's been banned by statute in some states. Florida has actually said they will no longer accept springing powers of attorney, even from other states. So if you have a Connecticut springing one, it still will not work in Florida. And the reason it's being banned is because it's the most abused document. So we really want to have a good power of attorney. Medical releases or authorization, I mean, most of us have heard of HIPAA. Now, we want to make sure someone can access the information, have a conversation with a doctor, and handle our financial planning. Also talking to insurance companies related to coverage issues. So having a good medical release is really important and is a good part of the life planning. So one of the things that's unique in Connecticut is we can pre-designate someone to be a conservator. Now, a conservator is that person that's appointed by the court to manage the financial stuff. And generally, if we're going for conservatorship, there's usually a couple of scenarios where this is going to occur. One is someone hasn't done any planning at all, or they've done planning, but the planning wasn't sufficient to protect them or do what we needed it to do. Another very common one is family infighting. Lots of kids have fights. Everyone always says, my kids will never fight. I have a sibling, we fight. It's just the way it goes. So we always want to have these just to kind of prevent it. And the other common one is if someone is disabled and they're too young, so like an 18-year-old, they're not capable of executing a document or an estate plan, they may have a conservator or a guardian. Guardianship and conservatorship are basically the same thing, but they have some different definitions in what they're allowed to do. In Connecticut, a guardian is only for someone who's a minor or a disabled adult. And a guardianship is only good if there's a limited amount of money. So, for example, a guardianship is fine if someone has less than $10,000, but if we get over $10,000 in assets, we have to get a conservatorship to go along with the guardianship. And there's different levels of conservatorship. So you can have a conservator just for medical, a conservatorship for financial, a guardianship just for medical or financial purposes. There's a lot of different ways that we can divide these things up, and there are different tools. In Connecticut, we don't have a healthcare power of attorney. I hear all the time, hey, I have a healthcare power of attorney. No, you don't. You live in Connecticut. It doesn't exist here, and in fact, most states don't have the true healthcare power of attorney anymore. The healthcare power of attorney we're dividing it up, and it cannot be done in the same document as the regular power of attorney. In fact, we have a statute that prevents that here. So it's a separate agreement where we're basically stating what we want as our medical wishes in certain situations, and it allows us to appoint someone to be named as our healthcare representative on an as-needed basis to make medical decisions if we're incapable of doing so. Connecticut actually defines someone as being incapable of making medical decisions if they're unable to understand the nature and consequences of the decision they're being asked to make. That can be a permanent incapacity, but it can also be a temporary one. A few years ago, I had surgery, and when we woke up in post-op, I'm told I had some really interesting conversations with people that I do not recall any of, because I was not competent to make decisions at that point. They needed somebody else to be making them. How was the discharge planning going to go? I couldn't participate. I kept telling everyone I was fine, I'm told. I don't know. Clearly I wasn't, because it was a temporary incapacity due to the fact that they were giving me medication that prevented me from doing things. Yeah, wisdom teeth could be one of them. And it wasn't for wisdom teeth. It was for something else. But, you know, there's a lot of times where it could be a permanent or temporary incapacity. One myth, because it's always out there, is just because someone is diagnosed with dementia does not mean they're incapacitated. I have clients who have been diagnosed years ago and they're still legally competent. So I hate that there's that myth that exists of, hey, you have a diagnosis, you automatically can't do this. Not necessarily. You know, it's a time and place issue of whether someone has competency to act, and we want to really be respectful and see is someone capable of doing it. So the will is kind of our next thing, and there's a lot of different types of wills. You have to always, again, just like anything else, wills are situational. What do we need in this situation? So generally a will is designed for someone to handle documents after passing and to handle it in what we call marshal the assets for administration. Now, one of the more common myths I've seen with these things is that, hey, I'm the executor. So the person's alive, it means absolutely nothing. If someone is deceased, it still means absolutely nothing. No one is an executor until a judge actually appoints them. There's no legal status to be an executor. The only person who can determine who's an executor is a court of law. So in Connecticut, until a judge says you're the executor, you're just a person named in a document that may or may not have legal responsibilities at some point. So we always want to do it. The will allows us to do distributions to individuals in a number of different ways. So distributions can be outright, which is pretty basic and simple, but they can be done in a trust as well. And we can put special needs trust into a will, although unless it's necessary, I prefer doing a special needs trust through something else that we'll talk about in a little while, but it is a doable thing. You can have a special needs trust in a will. The negative to having trust in wills is that you have to pay the court to do an accounting. In the old days, and by old days I mean like 2.5 years ago, it was $25 to file an accounting. It's now a sliding scale based on the dollar figure of the assets in the trust. So the more money that's in the trust, the more money you have to pay the court for the accounting. And the accounting rules are somewhat loose in Connecticut. The law says that the judge can determine the number of accountings. So they can do it every year, every 2 years, every 3 years, every 5 years. It's really up to the judge to make that determination. One thing that kind of goes back to the whole, hey, who can, dementia, whether you can sign something, is capacity. And this also goes to whether someone who has a legal guardian can execute a power of attorney. Someone has to have what's called testamentary capacity to sign a document. Capacity differs depending on the document you're signing. So testamentary capacity is what's required to execute a will. It is a lower standard to execute a healthcare directive. Healthcare directives require contractual capacity. So each thing has its own little level of rules. In general, though, for someone to be competent, they have to be aware of the natural people that they could be naming, basically their family members, a spouse. They have to understand that whether they have property, and they have to understand the consequences of whatever they're signing. So we don't just go, hey, you need a power of attorney. Are you able to sign one? So one of the questions is, should my child who has a guardianship do one? Maybe, maybe not. We want to see what their capacity level is to be able to do it. So it turns into, this is my favorite document, the revocable trust. It's kind of weird to, for attorneys to have a favorite thing, but this is my favorite. And why is it my favorite document? I mean, I have my own trust, and there's a lot of reasons why. My trust helps me avoid a lot of problems in my lifetime. First of all, it holds ownership of a lot of assets that I have. So my house is in my trust. Now, the reason I move assets into my trust is if I get sick, it makes it easier for somebody else to make transfers of my assets. So my successor trustee is my sister. If I get sick, she can sell my house. She doesn't have to go through the hurdle of trying to do it with a power of attorney, which could require a lot of documentation. My assets, when I pass away, don't go through probate. So I don't have to worry about a judge overseeing everything. I don't have to worry about the expense if I keep assets in trust. And I can create a number of different methods for the distribution. So for example, I can have assets going outright. That's pretty simple. Here you go. My dad created a trust. He calls it the Speed Bumps Trust. And the Speed Bumps Trust is because every person my sister's ever dated, he wants to run over with a car. And what he's really worried about, though, is, she's going to marry a moron. So what we have to do is, Speed Bumps Trust is the idea is we hold an asset in there. So instead of having money go outright to her when someone passes away, the money could be held in trust, and that money can be spent for her benefit. It's her money. I don't own it as the trustee. The trust doesn't, keep it. It's only to be used for her benefit. But if she were to marry that moron and get divorced, they can't go after that money. So we have additional protection that way. We can also do other things with trust, though. So a trust can also allow for a distribution to be held in a special needs trust built into this. So one of the more common methods is what we call a cascading trust. And it basically says when I pass away in my trust, there's money that I'm leaving to my nephew. And my nephew's going to get that money, and it's going to stay in trust for him. And it's there for his benefit. It can't be used for anyone else. It can be invested and increased for him, but it's his money. Now, it's his money, but it will not count against him for benefit purposes. So if he were to apply for SSI or SSDI when he got older, he's not going to use or lose those benefits as a result of the trust I've created. And the state will not be able to put a lien against those assets, nor can they restrict the distributions. The trustee has the flexibility on utilizing that money. So if the trustee wants to use that money to pay for education, they can, and it won't impact his benefits. If they want to use that money to purchase a house, unlike with SSI, they can, and it won't cost him his benefits because the trust was allowed to provide him things, and it's an exemption under federal law. Despite what Social Security says, there's a lot of things we can do with a third-party trust that will not cause someone to lose their benefits. So when we're looking at these things, there's a big secret in planning. And that is that the more we plan, and planning for these things gives us peace of mind because we have control. That's the number one thing almost everyone is concerned about when they come in for a plan. We all fear that loss of control. Deep down inside, all of us like to have control. We're all control freaks to our own degree. So planning is the one way we stay in control. Me having a plan at a younger age isn't because I'm afraid I'm going to pass away all of a sudden. It's because I pre-made a lot of my decisions already. So now when I let somebody else take power in the future, they have to do what I said. They're essentially my employees. So my trust dictates this is what is going to happen, period. And that's where the planning comes into play. We get to pre-plan for a lot of things. So when something does come up, it's not a crisis. And that's one of the big things we want to avoid with planning. We've nicknamed this the crisis cycle, and it's something I see all the time. If you think about it, we all probably done this too, and we kind of spiral. We have that event, that thing that happens to us where we lose some quality of life, and then we start coping again. And we do the same thing over and over again. We have another crisis or another event, And a lot of times it's a healthcare event. So essentially, we end up kind of repeating this crisis over and over, and we keep doing the same thing all the time. By planning, we kind of avoid that, and we have what we call the transition. And if you think about it, a transition and a crisis are the same thing. They're the same event. They're the same occurrence. It's still something that has happened that has a significant impact on us. So in general, when we're doing these things, by having a plan, we're going to transition because we can be proactive. We can oftentimes, when we do a plan, it's not a plan. It's a plan A, a plan B, and a plan C, because there's no perfect plan. Nothing always works according to plan. So we want to be prepared for the different things. And that's really what we want to be looking at here. We want to have that kind of transition. So I see a bunch of questions coming in. So I'm going to, Will. All right, so the will doesn't have anyone appointed until the judge does it. How does this impact the will in terms of timing of execution? I mean, it doesn't impact the timing of the execution of the will itself, because it depends on, you still have to have it done and have everything completed. As far as the actual handling of the estate after someone passes, it does have an impact, obviously. I mean, there's always bills that are not paid until someone gets appointed. That's where a trust has its advantage, is that we don't have to wait for the court. The trust gives us that power right away, whereas the will, we have to wait for the judge. How long does the process take for a judge to appoint someone? There's a lot of variables there. I'd say the average is probably 30 days from the date it's filed. So, and that's the key, is it's not like it's automatic. You have to have someone file the documents with the court, and there's a process to go through that, which usually takes about 6 or 7 days. So it depends. I'd say the average is about 30 days from filing. Even right now during the pandemic, we're still seeing appointments occurring. They haven't slowed up that much. It's taking about a couple weeks longer, but it's still happening.
Do you want our help with the questions?
Sure.
Okay,
well, and then once a person has passed away, the will is not executed. The will has to be executed before they pass. They have to sign it first.
Okay, Peter, hi Peter. He wants to know if you can comment on the advantages and disadvantages of a special needs trust being
revocable or irrevocable.
Can you paraphrase that question? I don't know if I understand it.
So I think I understand your question. So you're saying, on a special needs trust being revocable or irrevocable, and what's benefit or disadvantage of it? And the answer is, it's mixed. So the special needs trust itself is generally going to be an irrevocable trust once it's funded automatically. Whether the trust is created through a revocable trust or an irrevocable trust is a little bit of a different issue. There's no advantage or disadvantage to creating one under one or the other. They will operate in the same way. But once the special needs trust is funded, it's generally going to be an irrevocable trust, because you having the ability to change its terms is going to be a big deal, and they don't like it. Now, I generally try to draft mine in a way where it's not considered an irrevocable trust until there's a certain dollar figure in there to give us a little flexibility, but it's not a high dollar figure. You're talking, $100, and then it becomes irrevocable. So when we're looking at, revocable versus irrevocable, it's always going to end up as an irrevocable trust. It might be created revocable to start, just because it's easier to negotiate and change language if Social Security decides they want to change, or in Connecticut, usually it's the Attorney General's office.
Jeanette wanted to know that she's got legal guardianship over her daughter. Does she need power of attorney too?
Generally, no. If you have legal guardianship over someone, a court has already declared them to not be capable of executing legal documents. So in general, they're not able to actually sign one at that point. You have to essentially get a judge to say, hey, they're competent to be able to sign things. So no, you don't need both. Legal guardianship is generally going to be enough. Now, you may need a conservatorship if your daughter gets too much money, because over $10,000, a guardian is not allowed to manage money in Connecticut. At that point, the guardianship of what we call the estate or the finances would cease and you need a conservatorship for that money. Oh, I see. Vic, in what way, Vicky? I see the question about what about conservatorship?
You have to unmute her. Or Vicky, if you could unmute and ask your question.
What I was talking about was that you were talking about the guardianship and what papers, but what about like a healthcare directive or not, you don't need a power of attorney, I don't think, with the conservator. I have a voluntary conservatorship for my son. He went with me to the court when he turned 18. He's now 27. And so we've used the conservatorship for me working with his bank, being able to get his doctor records. But now that we're all doing this thing with the COVID, people are talking about the healthcare directive a little. I have the conservatorship of the estate and the person. So I didn't know if there's things he still would need to do or I would need to do.
No, you have the authority. A conservator of the estate gives you full authority to act. So you don't need to do anything on the financial side, and conservator of the person allows you to make all of the medical decisions. Because it's voluntary, there's not been a finding of competency or capacity, so it technically can be rescinded at any point in time if you wanted to.
Right.
And then he could go execute something, but there's no real need for it if everything is working at this point.
Okay. Just everybody's saying, oh, you should have an end of life, living will, whether I can make all the decisions or whether he should have his own independent living will.
You have the right to make the decisions. Now, that doesn't mean he shouldn't do one, because he can do something. It's not designed as just making decisions, but it's also him pre-making and declaring, like, this is the things I would want to have happen if I was in an end-of-life situation where I'm not capable of making decisions. This is what type of treatment I would or would not want.
Okay, yeah, because he's high-functioning autism, and so there are things he does decide. I sort of let him lead a lot of things, but there are times when I just want to make sure we've got him covered and protected.
Yeah, I mean, the guardianship or the voluntary conservatorship will work here. You don't need to do anything else. It's more of a question of, does he want to, and do you want him to?
So Stephen, what would be your best advice to special needs families? What, in a nutshell, what would you say they need to do?
Plan. My best advice is always to start planning. Start with your goals. Just make a list. I mean, the first thing I do for every client I see, we send them out something. We basically say, hey, what are your goals? Because that's going to guide a lot of the planning. And then if we create a plan that doesn't meet with those goals, then we need to see, was it an issue with the goal itself, or did the plan that we ended up deciding on not really work the way we wanted it to, and should we revisit the planning again? We want all of our plans to kind of work within your goals. You have to decide what you hope to accomplish. I really despise the planning by numbers thing where everyone does the same thing. All my planning is designed to be about your goals. So think about it, and think about it as a family. Sometimes, not everyone's going to agree. I had an appointment yesterday with a husband and wife. They had two very different sets of goals when they actually sat down to discuss it. And we had to work through that as part of the planning. So the best advice is always to have a plan. And if you think you have a plan, you might not. Plans should never stay static. We always need to be reviewing the plan. My general rule of thumb is every 3 years, we want to be updating, making sure everything is current and still works the same way, because laws change, situations change, policies change. So we want to make sure everything is really designed to work within those changes. I had one recently where someone came in and said, hey, I just realized, this person that I named as a backup for a special needs trust for my son has been deceased for 9 years now. Do you think we should update it? Yes, I do. But to do that, that's why we say, like, every couple of years, just check them, because people die. We lose friends where we don't trust people the same way. Finances change. So we always want to be making sure everything stays current. So we want to have a plan, and then we want to constantly be working on the plan or updating it and just making sure it always works the way we want it to. My theory on plans is always it doesn't have to be overly complicated, but it has to work. And a plan doesn't work if it's not going to do what we want it to do, doesn't meet our goals, and it hasn't been up to date and made current. So start planning. That's my number one.